see everybody. Jonas Callis of the Hurt at Work Workers' Compensation Law Firm. Many of you know me as the Workers' Comp Guy. Today I wanted to talk a little bit about the concept of statute of limitations. During my time as an attorney, I have fielded many questions about statutes of limitations. Primarily, what is it is the question. But actually, when people ask me what is it, they're actually usually asking one of two questions. Some people are actually asking that, they don't really understand what it is at all. And they're actually asking, what does that mean even? Like, what is a statute of limitations? And other people, though, kind of understand what a statute of limitations is. And they're actually asking me, what is the statute of limitations for filing a certain type of claim with the courts or with the Virginia Workers' Compensation Commission? So I want to talk about that a little bit today because it's a very, very important topic. I feel like most people have actually heard the term statute of limitations at some point, whether because you're actually involved in something that's a part of your life, or maybe you've been watching reruns of Law and Order or something like that, where I feel like in litigation shows and movies, statutes of limitations is a common issue that comes up because I think it's easy to write about and it's easy to understand for the most part. You may have heard phrases like the statute of limitations has run, or is it too late to file because of the statute of limitations, or something along those lines. And those are actually those are accurate statements, and they kind of tip somebody's hand of what it means really. So what is a statute of limitations then? A statute of limitations is a law that sets forth the maximum time, and that's typically measured from the date of whatever the alleged offense is, that a potential party has to initiate legal proceedings from the date of the alleged offense. And that's all it is, right? If you think about that, it's just a time limit for filing a claim, is all it is. It's important to note, though, that statutes of limitations can vary from jurisdiction to jurisdiction. And also they can vary depending on the type of claim that you're talking about. Now, what does that mean? For example, generally speaking, a lawsuit for personal injury in Virginia, it typically has a statute of limitations of 2 years from the date of the injury, the accident or injury. And so the injured party has 2 years from the date of the accidental injury to file a lawsuit in circuit court or general district court for that injury, okay? But while personal injury lawsuits have a statute of limitations of 2 years in Virginia, breach of contract claims for written contracts have a statute of limitations of 5 years in Virginia, right? Because it's just a different kind of claim with different evidentiary concerns. So people who want to sue someone for breach of contract typically have to file it within 5 years of the breach, okay? So those are different types of claims that have different statute of limitations. Now, contrast Virginia against the District of Columbia, where I believe the statute of limitations for both personal injury and breach of written contract claims is 3 years. So it can vary. It's something that can vary from jurisdiction to jurisdiction and by claim type. One important thing I wanted to note, though, right, is that I'm talking about breach of contract and personal injury, like lawsuit type of things, right? So criminal litigation, obviously, people have heard about statute of limitations for murder or rape or something like that in the criminal context. And I just talked about a couple of statutes of limitations in the civil context. Statutes of limitations are alive and well in the Virginia Workers' Compensation Commission. So we have to know that. We have to understand that. That's the first important step, right? You can't wait forever to file a claim. That's what a statute of limitations is protects against, okay? So sometimes I think it helps to understand the purpose of something, right? To better understand that something. For example, why can't you wait forever to file a claim, right? In other words, why is there a statute of limitations? Well, the statute of limitations, there are really two primary reasons, and they're both actually geared towards helping defendants. First of all, a plaintiff with a valid cause of action should pursue it with reasonable diligence, right? Like, if something happens to you, don't wait 27 years to file a claim for it, right? Like, that's ridiculous. Second, without a statute of limitations, by the time a stale claim, it's kind of stale if it sits around forever. By the time that stale claim is litigated, a defendant might have lost evidence or his or her opportunity to get evidence necessary to disprove the claim, right? So if you think about it, like a plaintiff may be gathering evidence the whole time, anything that he or she thinks is relevant, right? But the defendant loses opportunities because they don't even know they're about to be sued, right? If there were no statute of limitations. So that's why we kind of limit the time within which lawsuits or claims for benefits, if you're talking about the Workers' Compensation Commission, that's why we limit the time in which they can be filed. All right, so what are the actual time limits then for filing a claim with the Workers' Compensation Commission? I'm sure you guys are here to hear that, since that's kind of the point of this video. And the answer is, of course, it depends. Well, why does it depend? Well, first and foremost, the Virginia Workers' Compensation Commission has many different kinds of benefits it offers. So that's the primary reason, okay? There are 6 different statutes of limitations, or 6 different that I want to talk about. 6 different types of claims that I want to talk about, okay? And they kind of have varying statutes of limitations. But I feel like these are the most important. And it may be all of them. I can't think of any others. The 6 types are, number 1, accidental injury claims. If you've seen our website or our other videos, you may already know this, but accidental injury claims, also called injury by accidents. Number 2, occupational disease claims. Number 3, permanent partial disability claims. Number 4, permanent total disability claims. Number 5, death benefits claims. And number 6, change in condition claims. Okay, so let's start with the first one, injury by accident. This is by far the most common type of injury, number 1, type of work injury, and so therefore it's the most common type of claim. With regard to accidental injury claims, so remember, we're talking about an injury that occurs as a result of a specific identifiable injury or accident that occurred at a precise moment in time, basically, right, that resulted in injury. With injury by accident claims or accidental injury claims, the clock starts as soon as the employee is hurt at work. That's when it begins, okay? And again, if you've visited the website and watched the videos, you'll know that an employee, once hurt at work, has 30 days to report both the accident and the injury to a supervisor or manager of hers or his, okay? Now, the best practice, you probably also remember, is to notify, give the notice to your supervisor or manager in writing or electronically or something like that, but some sort of where you can have evidence of it, okay? Now, ninja tip. This is why I mentioned this. The notice part, the 30-day notice, isn't actually part of the statute of limitations, and that's kind of my point, okay? This is the ninja tip. It's important to understand for injured workers that giving the notice within 30 days to your employer, like your supervisor or manager, that you had an accident and you sustained injuries from that accident, that does not satisfy the statute of limitations deadline, okay? You still have 2 years within which to file a claim for benefits with the Workers' Compensation Commission, not the Workers' Compensation Insurance Company. That's a different thing. The actual Workers' Compensation Commission, okay? So it's important to realize reporting it to your supervisor does not satisfy statute of limitations. And as I just mentioned, the applicable statute of limitations for injury by accident claims is 2 years from the date of the accident. Now, I note that the claim for benefits, and this makes it even easier, really. The claim for benefits, like the injured worker does not have to even ask for a hearing at that point, or even prove, have all the evidence there to prove their claim, prove their entitlement to disability at that time, like within the 2 years when they file the claim. All they have to do is have some evidence of disability at the time they file the claim. So if you have some medical records, you file the claim within 2 years. There's really not much of an excuse not to do it, especially now that you know, right? So And just so you know, when an employee files some sort of claim but doesn't really ask for a hearing or request specific benefits, that's acceptable, right? That's acceptable for filing a claim. And the commission may label it an assertion of rights, but it still satisfies the statute of limitations deadline. So just so you know, assertion of rights is a good claim for benefits. It's a valid claim for benefits that preserves the injured worker's right to benefits. The time for filing a claim, in terms of whether it's been filed within the statute of limitations or not, the statute of limitations is rarely extended. There are certain circumstances where it could be, but it usually doesn't happen, and it usually doesn't work out for the injured worker. It's just not something you want to mess with, really. So by filing the claim within 2 years of the work accident, what the injured worker does is preserves his or her right to all the benefits that he or she could be available to. Lifetime medical benefits, temporary total disability benefits, temporary partial disability benefits, permanent partial disability benefits. So it's very important to file the claim within the appropriate deadline. Occupational diseases. Not as common as injuries by accident, but they still happen. And it's a bit more complicated to figure, but not a lot, but a bit more complicated to figure out the statute of limitations filing deadline for an occupational disease versus figuring out for an injury by accident. For occupational disease claims, the most important date is the date that the injured worker is diagnosed with some sort of disease and told by, usually the healthcare professional that's doing the diagnosis, and told that the disease is related to his or her work, okay? That is when the statute of limitations starts, okay? And so basically, the date of that communication serves as kind of the date of accident. If you're trying to compare it to the injury by accident claim, in occupational disease claim, the date of the communication is kind of the start date for the running of the clock, okay? So examples of statutes of limitations for specific occupational disease claims. Coal workers' pneumoconiosis or black lung disease. In typical cases of like that, after the worker advises the employer of the diagnosis, the employer is actually supposed to provide there's a standard notice that the employer is supposed to give the injured worker, all right? Assuming all that happens, right, the worker must file a claim with the Virginia Workers' Compensation Commission within 3 years of the date that the diagnosis was first communicated to him or her, or the legal representative of his or her estate, or within 5 years from the date of the last injurious exposure, which is the date you last worked in that employment, whichever occurs first. All right. Asbestosis. A worker must file a claim within 2 years after the diagnosis is first communicated to her or him. Bisonosis. A worker must file a claim within 2 years from the date the diagnosis is first communicated to her or him, or 7 years from the date he or she was last exposed at work, whichever occurs first. Now, an ordinary disease of life. If you've seen our website and our videos, you've seen our discussion, the distinction between an occupational disease and an ordinary disease of life. For something that's an ordinary disease of life, which is something that the general public is exposed to semi-frequently, something such as carpal tunnel syndrome, hearing loss, mold exposure, a worker must file a claim within 2 years after the diagnosis is communicated to her or him, or within 5 years after the last injurious exposure at work, whichever occurs first. And the last one, other occupational disease. So basically, this actually, even though it's the last one, this applies to most occupational diseases other than the ones we've mentioned, right? So this is really the primary deadline. Worker must file a claim within 2 years of when the diagnosis is first communicated to her or him, or within 5 years of the worker's last exposure, whichever occurs first. So this includes claims such as claims that arise under the police and firefighter heart and lung presumption, and numerous other occupational disease claims, really. So that's those. Permanent partial disability claims. Again, if you've been to our website, reviewed our videos, you know that injured Virginia workers could be entitled to permanent partial disability claims when their workplace injuries result in some sort of, usually a permanent partial impairment or loss of functional use, or even if you don't have that, but have like a significant scarring or disfigurement from the work-related injury. Even if the injured worker is able to return to work in some capacity, light duty work or whatever, still would be entitled to permanent partial disability benefits. The injured workers would need to file a claim for permanent partial disability benefits within 3 years of the date compensation was last paid pursuant to an award order. Now, some work accidents, depending on what the job is and what the worker's job responsibilities are, some work accidents, even though they may result in somewhat of a serious injury, which could result in permanent partial disability benefits, they may not actually have caused the worker to miss too much or any time from work, okay? In a case like that, the injured worker might receive like a medical only award. That would entitle the worker to medical treatment benefits, lifetime medical award for all the injuries, the significant injuries, right? But if they didn't miss any time or they didn't miss more than the 7-day waiting period, they wouldn't be entitled to wage loss replacement benefits. In that case, the statute of limitations for permanent partial disability claims is 3 years from the date of the workplace injury to file a claim for PPD benefits. Okay, so it shifts a little bit. So that's something to be aware of. Moving on to permanent total disability benefits. This doesn't happen as often, but as you can imagine, it's very important, because if someone has really how you become entitled to permanent total disability benefits is when you have significant injuries to multiple body parts, or is paralyzed, or suffers a significant enough brain injury that renders in the injured worker unable to return to gainful employment. So we're talking about more serious types of injuries with the permanent total disability benefits claims. As you'll recall from the website and our videos, the permanent total disability benefits are payable after the injured worker has received 500 weeks worth of temporary total disability benefits, temporary partial disability benefits, and or permanent partial disability benefits, or some combination of those three for 500 weeks. Once he or she has received those benefits, that's when he or she would be entitled to permanent total disability benefits. But although the injured worker could file the claim for benefits if there's evidence of the permanent and total disability prior to the expiration of the 500 weeks, but she or he wouldn't be entitled to receiving those benefits until after the 500 weeks runs. But for statute of limitations purposes, for filing a permanent and total disability claim, the worker would have 3 years from the date compensation was last paid pursuant to an award order or an award. So how do you find this? And it's the same with the last one, permanent partial disability benefits. Well, the injured worker would actually, especially if you have multiple awards, the injured worker would actually have to go through all of the award orders and judicial opinions awarding periods of temporary total disability, temporary partial disability, permanent partial disability, and see the last date that they were paid for that, right? Like, through what date were you paid TTD, TPD, or PPD benefits, right? And then it's going to be 3 years from that last date, okay, within which you have to file the claim for permanent total disability benefits. The next type of claim, death benefits claim. As you might expect, because they're kind of multifactorial here, right? So it's a claim by a dependent family member for death benefits because their family member was injured at work and then subsequently died from that, okay? So the statute of limitations here is a bit more involved, but easy enough for everybody to understand that. So for a dependent family member to timely make a claim for death benefits, 3 different time limitations must be satisfied. First, the injured worker must have filed a claim for benefits within 2 years of the accidental injury. That makes sense, right? We already discussed this. Typically, injured workers don't necessarily know they're going to die. They don't know they're going to die 3 years and 47 days later, right? So initially, as an initial matter, they have a workers' compensation claim that they have to preserve, right? And they have to file it within the statute of limitations. So that's the first thing. The second thing that must be satisfied is the injured worker, as macabre as this kind of sounds, the injured worker must have died within 9 years of the accidental injury or the diagnosis of the occupational disease. So assuming those 2 things happen, the dependent family members are left with, a lot of issues that kind of the ripple effect of losing a family member. So the family member seeking death benefits must file a claim for benefits within 2 years of the worker's death, assuming that the worker died within 9 years and that he or she had already filed a claim for benefits within the statute of limitations. Unless the worker's death was caused by coal workers' pneumoconiosis or black lung disease, which is kind of like an occupational disease, in which case the dependent family member has 3 years from the date of the worker's death to file a claim for benefits instead of 2 years. So that's an important distinction. Now, lastly, the last statute of limitations I want to talk about is change in condition claims. The previous types of claims we've talked about today, all the ones before this, were kind of substantive claims that provide actual benefits and payments and stuff, is like for kinds of injuries and that kind of thing. All right. This is a little different. A change in condition claim applies to all those claims. It's really more of a procedural thing. It's basically when whatever your injuries are, when your condition has changed, hence the name, right? So it's not for a specific injury or benefits available. It's just it's when the injured worker's condition changes or worsens after his or her workers' compensation claim has already been approved, right? After he or she's already receiving benefits pursuant to an award or judicial opinion or whatever. For example, maybe the injured worker returned to light duty work at one point, but then was subsequently taken out of work again by her or his doctor, which would entitle him or her to temporary total disability benefits, right? That would be a change in condition to which she or he would need to file a change in condition claim for benefits to get those benefits. The Virginia Workers' Compensation Statute of Limitations for filing a change in condition application is 2 years from the last day for which compensation was paid pursuant to an award order. And when I say award order, it also means judicial opinion, just anything that awarded the injured worker benefits, right? And again, it's going to have to go through all the award orders and judicial opinions and everything and see the last time she or he was entitled, through what date was she or he entitled to temporary total disability, temporary partial disability, permanent partial disability benefits pursuant to the award order or judicial opinion. And it's going to be 2 years from that last day. All right, so an important ninja tip here, right? Pursuant to Rule 1.2 of the Rules of the Commission, a change in condition claim for additional wage loss benefits, the injured worker can only reach back 90 days from the time you file the change in condition claim, okay? So 2 things to remember from that. First of all, remember, it's a change in condition claim. It's not the initial claim for benefits, right? The change in condition claim is after you already have received benefits. You've already probably litigated or adjudicated your right to benefits, all right? This is when your condition worsens sometime later or something, or you're just entitled to a different kind of benefit. Once you file it, you can only reach back 90 days, right? So what does that say? The takeaway from that is it's important to file. Once you realize that your condition has changed, file the claim ASAP, right? File it as soon as possible, because if you wait and don't, you file it later rather than sooner, you're just cheating yourself out of benefits, really. So that's the first ninja tip. Another ninja tip, and this is important because some Virginia workers' compensation attorneys seem to not even realize this. If you're paying attention, you might be wondering, well, Jonas, you just said with permanent partial disability benefits, that you have a 3-year statute of limitations to file those claims. But now you're saying that a change in condition claim, you only have 2 years to file the claim. And you'd be right. Like, that seems inconsistent, right? But what I said earlier, the permanent partial disability claim with 3 years for that claim is accurate, okay? It's just, it seems a little inconsistent, but it is what it is. Even though permanent partial disability claim is a change in condition claim because it comes afterwards typically, you do have 3 years for the PPD claim and 2 years for all other changing conditions that aren't PPD claims, if that makes sense. Tolling. Last thing I want to talk about is the concept of tolling, right? Anytime you talk about statutes of limitations, really you need to talk about tolling a little bit. Now, first, what is tolling? Tolling is a legal doctrine that allows for the pausing of the running of the statute of limitations, right? Such that a claim may potentially be filed even after the statute of limitations appears to have run. Okay, that's all that is, right? It kind of pauses it, right, to let it go a little longer. Now, given the concept of tolling, is an injured worker out of luck if she or he has waited longer than, let's say, 2 years for an injury by accident claim to file a workers' claim, a workers' compensation claim for benefits with the commission? Usually, yes. Like, tolling it's pretty rare. It's hard to get it to apply, and I'll tell you why. Section 65.2-602 of the Virginia Workers' Compensation Act addresses tolling directly, and essentially it allows injured workers to extend the statute of limitations for filing a claim if, 3 things: the injured worker gave timely notice of the accident to her or his employer, okay? 2, the employer continued to pay the injured worker regular wages while he or she was disabled from work and failed to report the injury, okay? And 3, the employer's actions prejudiced the injured worker. As you can probably tell, it's pretty difficult to satisfy those 3 things because it requires showing that the employer used its superior knowledge or its economic advantage to deprive the injured worker of benefits. And it's especially true, here's the thing, here's the kicker. It's especially true in light of the fact that the Virginia Workers' Compensation Commission, once it receives like a notice of an injury, notice of accident, notice of injury, it's standard procedure to send a notification of rights letter to the injured worker at the known address, okay? So, if the commission sent a copy of this letter and it's standard operating procedure to do so anymore, and there's no evidence that the letter was returned by the Postal Service, the injured worker is unlikely to win any argument that the statute of limitations should be told, okay? Now, that brings me to my last ninja tip. As you can see with most claims, the statutes of limitations are 2 years or 3 years or 5 years or whatever they may be, okay? While claims are not always capable of being filed immediately, certainly they're capable of being filed within 2 years, 3 years, 5 years, right? Now you know. Like, I've gone over these claims, you know the statute of limitations, right? Now you know, right? And it makes no sense to sit on it and wait, right? You're not going to get any benefit. There's no benefit gained by just waiting until the statute of limitations approaches and then filing it the last day or something, in which case you may miss it. There's just no reason to do that because you don't gain a benefit from doing it, all right? So do it as soon as practical and move forward with your claims. There'll be enough things to fight over. Don't make statute of limitations an issue that you want to fight over as well because you're probably going to lose that one. In which case you won't be entitled to any benefits at all if you lose that. I think that's all I wanted to cover today about statutes of limitations. It's a very important topic. It's not complicated, but it's very important. And it's important, just file the claim, right? If you have a claim for benefits, file it and then sort the rest of it out later. But get the claim filed timely. Thanks for watching this video. I hope it was helpful. For more information, check out our website, www.hurtatworkinva.com. That's HURTATWORKINVA.com. And check out our other YouTube videos. We discuss a lot of this stuff. The website and the videos are chock full of information to help out injured workers who otherwise maybe don't have the resources to learn or understand about Virginia workers' compensation laws. And the other thing is, if you find this information and the videos and the website helpful, chances are other people would too. So tell your friends, tell your family members. They may be going through the same thing and you not know about it. They may know someone who's going through the same thing and you don't know about it. So I always feel like it's better to have the information and not need it than it is to need the information and not have it and not know where to go to get it. So that's why we do this. I think that's all I got for now. Stay safe and don't get hurt at work.